Good evening, everyone, and thank you for attending tonight's Research Tuesday event, Change for Good, celebrating 10 years of the South Australian Law Reform Institute. My name is Nigel Rogash, and I'm a Senior Research Fellow in the Adelaide Medical School here at the University of Adelaide, and I'm also your MC for this evening. I'd like to start by acknowledging the Kaurna people, the original custodians of the Adelaide Plains, and the land on which the University of Adelaide's campuses at North Terrace, Waite and Roseworthy are built. In tonight's presentation, we reflect on a decade of law reform in South Australia and the incredible work of SALRI that SALRI has achieved. The independent South Australian Law Reform Institute, based at the Adelaide University Law School, was established in December 2010 under an agreement between the University of Adelaide, the South Australian Law Society and the state government. For the past decade, SALRI's work has helped lead to landmark changes to many of the state's laws in diverse areas. SALRI is unique amongst law reform bodies in its links to a law reform class. SALRI draws not only on its extensive consultation and research, but also the major contribution of this law reform class. Tonight, you'll hear about SALRI's role and work, highlighting some of the involved and often sensitive references it has conducted over the last decade, including an improved surrogacy framework in SA, the complex issue of abortion, the common law forfeiture rule in unlawful homicide, the role and operation of powers of attorney in SA and communication partners to assist parties with complex communication needs in the justice process. Our presenters will discuss some of the key themes to emerge from a decade of SALRI's operation, notably the importance of modern law reform of active and inclusive consultation, including with Aboriginal communities. Ultimately, demonstrating law reform isn't just for lawyers. Following the presentation, I will open up the Q&A session with our online and in-person audiences. If you're online, we encourage you to submit questions during the presentation via the Q&A section down the bottom of your screen. I'd now like to welcome our presenters to the stage. Dr. David Plater is a Senior Lecturer at the University of Adelaide and Deputy Director of the Independent South Australian Law Reform Institute since 2015. David's research interests include prosecutorial discretion, vulnerable parties in the justice system, the prerogative of mercy and exercise of death penalty in the 19th century, modern law reform, and honest and respectful consultation. Anita Brunacci, a Senior Associate with DBH Lawyers and since 2018 has been working closely with the Independent South Australian Law Reform as a researcher. Anita has previously worked in Tasmania, initially in private practice, and then as the Deputy Manager of the Aboriginal Legal Service. Since returning to Adelaide, she has private legal practice and her role with SALRI and regular lectures at the University of Adelaide. Brooke Wischusen is a University of Adelaide graduate, having completed her Bachelor of Law, Bachelor of Arts, Diploma in Languages and Graduate Diploma in Legal Practices. In 2020, during her final year at Adelaide Law School, Brooke was an enthusiastic member of the law reform class, and after finishing her studies, was a research assistant on SALRI's most recent reference into communication partners. Brooke was admitted to practice in September 2021 and now works as a wills and estates solicitor at Varga Lawyers. So please join me in welcoming your Research Tuesdays speakers.
Thank you. It's a pleasure to be here. I'm grateful for everyone who's attending and everyone who's following online. Now, the South Australian Law Reform Institute was set up, as we heard from Nigel, in December 2010. We recently held our slightly delayed 10th anniversary at a reception kindly hosted by the Governor at Government House, owing to the recent restrictions. So what have we learnt in 10 years? Well, firstly, a little bit about SALRI. I will be fairly brief because I really think part of the legacy of SALRI has been some of the difficult and sometimes controversial references that we've looked at, and also some of the themes. What have we learnt in South Australia from 11 years? Well, firstly, SALRI South Australia, as we all know, doesn't have the resources like a large jurisdiction like Victoria or the Commonwealth or the UK. So our law reform model is the so-called institute model. It has advantages and flexibility. It consists of a partnership between the local and state government, namely the Attorney General, the Law Society and the university. Now, there are pros and cons of the various models of law reform. What they all have in common is impartiality and independence. We are not an advocacy body. I'll return to that theme shortly. One of the advantages of the institute model is being able to draw on the goodwill, the collegiality and the participation of enthusiastic students, here looking at Brooke, and enthusiastic colleagues from private practice, looking at Anita. I have a reputation for being, if people say, I'd like to help you, I actually take advantage. Don't take advantage, I take full benefit of these opportunities. Because one of the strengths of SALRI, as Nigel touched on, it's myself, point 5, I've another role at the university teaching, our fantastic director, Professor John Williams, who has various other roles too, and our tireless executive officer, Louise Scarman. So one of the themes I think we know is small is not necessarily bad when it comes to law reform. It's been able to draw on the goodwill, the collegiality and the participation of other people. We're assisted by an expert advisory board, and also we have a number of specialist researchers from the law school, other schools at the university, and particularly former and current students. The role of the law reform class is really integral to SALRI's output and its work. And I also said we're very careful. We just don't set ourselves up as some academic ivory tower, as perhaps law reform was done a generation ago. Justice Kirby, in his inspiring legacy as the inaugural director of the Australian Law Reform Commission from 1975 to 1985, highlighted law reform is not just for lawyers. What Justice Kirby means by that is we need to move, and certainly SALRI and modern law reform agencies have, from a purely elitist approach to law reform. You need to move beyond experts, lawyers. They have valid views, but you need to go out to the community. You need to speak to interested parties, experts, NGOs, and particularly traditionally overlooked communities. And one of the themes we've found in our work in South Australia has been the need to involve Aboriginal communities. Not in tokenistic consultation, as sadly is all too common, but an expression which Nigel touched on, one of the elders quoted to the class in Brooks' year, honest and respectful consultation. An emphasis, SALRI is non-partisan. So we work effectively, we're not an instrument or an agency of the state government, we work effectively with either a Labor Attorney General, as the picture shown there with myself, my colleague Dr. Silva Villios, Professor Williams and the former attorney John Rao, and we work equally effectively with a Liberal attorney. The picture there on our surrogacy report, myself, Professor Williams, another fantastic student, Ms Thompson, and the attorney at the moment on surrogacy. Non-partisan. So what does SALRI do? Again, I'll try and not get too bogged down in this. So we receive references. That's just a project. Now, the reference could come from the Attorney General. The attorney of the day might say, I want you to look at issue X or issue Y. But one of the advantages of SALRI is we're outside government. Members of the community are quite often more willing to engage with a non-government law reform body. And also SALRI can initiate its own references as approved by the advisory board. And our recent reference into the role of communication partners to help vulnerable witnesses is an example. We're very clear. We don't set out with a preconceived conclusion. We have terms of reference, so we don't go off on to try and reinvent the wheel. So we have terms of reference. We conduct wide multidisciplinary research. Another theme of Justice Kirby, law reform is not just for law. You need to look at other disciplines, other areas of study. Consult widely with the community, interested parties, experts, look at laws and experiences elsewhere, both in Australia and overseas, and then we issue a report. Now, some of our reports have been 100 pages, our most recent one was 500 pages. The abortion report, for example, was obviously a complex and sensitive issue, was about 550 pages. And we say, these are our recommendations for changes to law and practice. and the reasons why. Implementation is ultimately entirely an issue for the government of the day and Parliament. Though saying that, we've had a very productive take-up rate by the government of many of our past reports. So our functions: to modernise the law, eliminate defects in the law, consolidation, the repeal of laws that are obsolete or unnecessary, or sometimes when it comes to the context of some of you may have heard our earlier lecture this year on the so-called homosexual advance defence, defences which are frankly outdated and now offensive. Uniformity, where desirable, between the laws of the various states in Australia. Now, Brooke is looking at me with a dry smile. If any of you have ever tried to produce uniform laws between all of the states in Australia, it is no easy task. The former Attorney-General, Mr. Rao, once said in Parliament, quote, "Glaciers will melt quicker than trying to get uniform laws in Australia." However, it can be a valuable aspiration. I'll touch on this briefly. The work before SALRI, there was a body, part-time body, composed of Justice Zelling and part-time lawyers, produced 106 reports. Really impressive output. That was a different era for law reform. The work of the South Australian Law Reform Committee was very much on lawyers' law. That is, we're not going to intrude on areas of public policy. Those are areas for other disciplines or for the government. Technical areas of law. Little, if any, community consultation. The focus then was very much law in England and Australia. Other jurisdictions didn't really matter. They had extremely limited resources, a lot of goodwill. Now, in the 1980s, there was a backlash against many law reform agencies in Victoria, Canada, and partly here. There was a view that the South Australian Law Reform Committee had outlived its usefulness. Law reform work could be performed within government. Why have an external standalone body or agency? However, it was found that there was a real gap because there are various benefits for the government and the community in entrusting particularly complex or sensitive areas of law to an independent body outside government for consultation. So SALRI was SALRI was formed in December 2010. There was seen to be a gap. However, as I said, the flexible institute model, which is based on the model in Tasmania and Alberta, was seen as the preferred model, rather than the more expensive model of a full-time commission, as in Australia, as in the Commonwealth, the UK, or Victoria. I emphasise again, we are not an advocacy body. Our role is objective and impartial. We recommend on the basis of our terms of reference and our research and consultation. It's not to say that there's anything wrong, obviously, with an advocacy body, but that's not our role. Now, our reports may well be used by social justice, advocacy, or human rights bodies, but that is a separate process. So, as I said, an emphasis on what we are not. That's not in any way to devalue the work of such bodies, but once we become an advocacy body, or we're seen to too closely identify with one political viewpoint or the other, we erode our crucial independence and impartiality. SALRI turns 10. That's a picture of our various researchers, colleagues, and the former Chief Judge, who's not a valuable contributor to SALRI at Government House on our recent 10th anniversary. Well, what themes emerge? For those of you interested, the link at the bottom of that slide is the Governor's insightful comments, where she generously acknowledged SALRI's valuable contribution to law reform and the administration of justice in South Australia. So what themes emerge from 10 years? One of them is the pivotal input and commitment of the law reform class. I would say that the law reform class is integral to how SALRI's been able to have such a powerful output and impact over the last decade.
Yes, my name's Brooke, and I was in the law reform class last year, and I'll just start off by talking about what the students get to do in that class and how they get there. So it's not like a normal class at the uni where you just decide you want to do it and you enrol. The highest kind of GPA students in each year are invited to join, which means that all the people in the class are very smart, they're very dedicated, they're very hardworking, and they're very driven. And then once you're in the class, you are able to look at an area of the law that needs reform. So David gave us a list of topics that were either current references or something that he thought could become a reference, so that we're able to look at an area that is relevant to where we are at the moment in our legal careers, and are able to do work that could actually make an impact and could actually lead to reform, which is amazing when you are studying that, knowing that the work you're doing isn't just to get an academic mark, but to actually make change and be a part of something a bit bigger. So a lot of the students who wrote on some of the references that David's mentioned, so abortion, surrogacy, our recent communication partners, their work is used for the report and they are acknowledged in the report. So it's the only law reform body in the world that uses undergraduate students, but I think for South Australia especially, being such a small area, it is really important and means that our reform isn't just people who have been in the profession for a long time making the decisions or making the recommendations. It means that it is going out to a broader range of people and not only benefiting the Law Reform Institute, but also benefiting the students as they're in their final year of law and are going to start their legal careers. As well as helping with the research, being in the class also means that you get to hear a lot of very important guest speakers. So these are people who are very highly regarded, sometimes in the legal profession. So down the bottom we've got Justice Bleeby with all the students. So he's a Supreme Court judge and he's very highly regarded by the South Australian legal community. He also used to be the Crown Solicitor. Up the top there we've got Michael Kirby, His Honour, who I'm sure many people would know is a former High Court judge. And then we also have students in Parliament House. So that's just, it's something you wouldn't get in another subject, and it's amazing that the University of Adelaide and SALRI is able to offer this to students. So we've talked about how students kind of go in to these research assistant roles afterwards. What we did in my year is we looked at the previous consultation videos, which we used to engage the public in our issues. They're laughing because the old ones were terrible. So we got one of the old students from my year, Lucas, to redo some of the videos, and I'll just play part of it for you now. We've got it here. So this was for our reference that we just finished, communication partners, and the goal of this video was to get the attention of the general public who might need to use a communication partner at some point or know someone who might, and actually have them be able to understand why we're doing this and why we want their input.
Anyone could have to give evidence as a witness or a defendant in court. It could be you, a family member, or even a friend. But what if they had communication needs and required assistance in giving this evidence? In South Australia, witnesses and defendants with communication needs can get a communication partner to help them give evidence, whether it be inside of court or outside. However, there may be some issues accessing the current program.
The communication partner, also known in other places such as England as an intermediary. It is designed to assist or enable parties with complex communication needs. When I mean parties, it could be a witness, a suspect, a defendant, a victim. The role is designed to provide advice to the court,
And I'm just going
to the
jump
investigator, say it's a
such as children and people from non-English speaking backgrounds. The presence of a communication partner can significantly improve the quality of the evidence given by the witness. However, it's also important that the evidence is not distorted in any way. And so the role needs to be clearly defined and the program needs to function effectively so that fairness is afforded to all the parties involved in the legal process.
So what can we do to improve access to communication partners for vulnerable witnesses and defendants? Should we further define the role of a communication partner? Do we need to increase training materials and educational programs for law enforcement, the legal profession and the community so that they are aware of this communication partner model and thus able to use it? And can we improve access to regional South Australia? SALRI, the South Australian Law Reform Institute, is looking into the effectiveness of the current Communication Partners program. If you would like to share your thoughts with us, visit our website or send us an email.
So as we've discussed briefly already, and we'll come to it again throughout the presentation, community consultation is incredibly important if you're wanting to suggest reform that is actually going to have an impact and that is actually going to have a positive change for the community. And those videos are just one way that we try and reach out to the community so that they can understand what our reference is, what we're wanting to do, and what kind of needs to be changed or possibly could be changed, and get their opinion on that. So we also, as you saw at the end, invite people to email us. We sometimes have things go on the Your Say website. It really varies from consultation to consultation. And we also, which we'll come to later, do go out to regional communities and also have roundtables as well.
Thank you, Brooke. So you see the impact of the students is really profound. The other law reform agencies are either full-time bodies funded by the government, like the ALRC, or the institute model in Alberta and Tasmania draws merely on postgrad students. There's a real plus. The commitment and the insight brought by our undergrad students, both in class and as research assistants after graduation, has been quite striking. So SALRI may be small in size, but over a decade, as this picture at Parliament House of the Honourable John Dawkins demonstrates, has really had a major impact in many areas of law reform. The second lady across there is Miss Thompson. So she looked at surrogacy as part of her work in the law reform class. Her work was exceptional. We had a bit of funding from the government, never as much as we would like, but you know, you have smelled, sometimes we think SALRI runs on the smell of an oily rag, and her work during this reference and consultation, particularly with intending parents and with surrogate mothers, was really powerful. Her work was quoted by John Dawkins. John Dawkins had spent 20 years agitating in Parliament for surrogacy law reform. Maddie had the dubious pleasure, to quote Mr Dawkins, of having read every word he had said in Parliament over the preceding 2 decades. And Maddie's work was quoted in Parliament. Her name was quoted in Parliament. So it really illustrates the point that Brooke made, the profound impact that SALRI can and has made over recent years. Now, I'm going to touch on this very briefly because I really want Anita and Brooke to talk about some of our references and some of the themes. What are some of the themes that have arisen from the past decade? Well, one is the dramatic impact of technology on modern law reform. How can the law keep change? Not just with the amazing changes in technology, but with the behaviour that goes with it, both for good and for evil. Looking there at the notorious Shannon McCool, cybercrime, electronic evidence, many areas. Now, as Brooke and Anita will confirm, my IT skills are not renowned. It's something how it's incumbent on any modern law reform agency, the dramatic impact of technology. Now, this is a reference, also the value of history, because there are valuable lessons to be learnt from history. Sadly, in the law, history does repeat itself. Now, the common law forfeiture rule was a recent reference that we looked at. This is no statute. This is a court ruling in 1892. Florence Maybrick, the lady on the left, horror, in 1892, was having an affair when she was married. She was alleged to have murdered her abusive, drug-addicted husband, Mr Maybrick, through the use of arsenic poisoning. It was a sensational O.J. Simpson case of its era. Mr Maybrick is now alleged to have been one of the many suspects to be the notorious serial killer, Jack the Ripper. This case, however, raised the profound legal question. Could Mrs Maybrick inherit from her deceased husband's life assurance policy? The trial was controversial. She seems to have been convicted as much because of her private life as upon the strength of the prosecution case. She ultimately wasn't hanged, but the English court said it would be an affront to civilization if a murderer could inherit as a result of their crime. Sounds sound, logical. However, in 2020 issues such as euthanasia, issues such as mercy killing, particularly the example of a victim of domestic violence who responds and kills their abusive partner. So the common law forfeiture rule, while sound in policy and sound in history, had modern problems. Also practical complications that Brooke can share with you if we ever had the time in relation to succession law. So our report said the policy is still sound, but it needs to be moderated. It needs to be far more nuanced than this all or nothing approach. Now I'm only going to touch on this very briefly because this was the subject of a really extensive reference that SALRI did several years ago, and I spoke about with 2 former students in April. The Governor address said the need to remove the criminal and civil law of discrimination on the grounds of sexual orientation, gender. So this was a major reference that we looked at. We looked at many aspects of civil and criminal law, and there was all-party support in Parliament. The legacy obviously is the tragic death only just down the road of Dr. Duncan in a homophobic attack. And there's the two value of law reform. It isn't just about changing the law, whilst that's obviously significant and important. It's also the form of civic engagement, the contribution of the community, described by Justice Kirby as civic engagement or deliberative democracy. So one of the reference was the issue that was of personal interest to me, because my background is in the English Director of Public Prosecution's Office, was the so-called homosexual advance and provocation. Some of you may have heard the previous lecture, so I'll be comparatively brief. This was this notion that if you were subject to a same-sex advance, the law partly condoned it. You might fly into a murderous rage as a result of a non-violent gay advance, kill the person who'd made the advance, and that would reduce the crime of murder to manslaughter. Complex, offensive, and obviously outdated. Our report was accepted by the government with all party support, didn't just abolish the controversial and outdated homosexual advance defence, but the whole wider defence of provocation, while still making provision for defences for victims of family violence. Now, the issue of surrogacy is one of the theme studies that we'd like to share with you tonight.
So what I would like to do is talk to you not only about SALRI's references, the more recent ones, but also how we go about these references, which, as David said, are a diversion from what was the Law Reform Commission's work many years ago, which didn't really look at anything of policy. They looked at very technical things. What SALRI has had recently has had referred to it things like surrogacy and abortion, which do have a really large policy element. I don't think anyone in the community, and certainly no one in government, would be happy if we gave them a report that just says, here's the technicalities, don't worry about what anyone feels about that. So surrogacy was the first report that I worked on with SALRI, and it's the first one, I think, really that SALRI had done that had a really large component that was outside of our expertise. So while law reform is not just for lawyers, as you've heard from David, it's made up of lawyers. He's a lawyer, I'm a lawyer, Brooke is now a lawyer. Very exciting. So we don't know anything really about medical, how those sort of things work. So what we did with surrogacy was we really reached out to the people that knew the answer. So the first question was, what is it and how do you do it? Because we don't know. And then when we answered that question, we could then take our terms of reference to start asking the community what their views were. So with surrogacy, one of the things that we learnt very quickly is the procedures itself are all very medical and very technical, but that doesn't help anyone when you're asking questions about it. So it's around owning the terminology that you use in consultation. So in regard to surrogacy, we were reading a lot of articles, and there's been a lot of work done on it internationally and throughout Australia. And we started seeing this term, Frankenstein's baby. Like, oh, that's not going to work. Because if you go out to consultation and we say, we want you to talk to us about Frankenstein's baby, if you're an intending parent, if you're a proposed surrogate, you're not going to feel welcome in that conversation. That's quite a confronting term. So Maddie, who you've seen a few photos of and who had read everything that the Honourable John Dawkins had put forward, She came up with a much better term. She came up with the term team baby. And we were very lucky that all of the media in South Australia liked her term because it took off. And that was a much more inclusive way of asking the question, because it didn't put a preconception into the question that you were asking. And I think what SALRI has learnt in its community consultations in the last 10 years is that's really important. It's important to let everyone who may want to contribute know that they'll be heard. Doesn't matter what their opinion is, whether they're for it, against it, indifferent, they have the right to be heard, and you don't want to start with a starting point where they feel like it's not about their opinion and it's not about their view. So with surrogacy, we owned that terminology. And it was a really interesting piece of legislation and something that I was really happy to start on, because it had wide-ranging support from all elements of government. Surrogacy already existed, but it had sort of been jammed into some pre-existing legislation and was really unwieldy. And it really wasn't compatible because of the interpretations in that legislation with all of the work that SALRI had done before on the LGBTIQ matters. So what our job was in the reference was to say, is there a way, or should there be a way of making a surrogacy framework for South Australia, and what would that look like? So what we had to do was go through everything that had come before, and there'd been the initial establishment of a surrogacy framework. There had then been some very well-meaning amendments to that, which had never worked, which had effectively made it unwieldy and impossible to use. And then there was our report. So from our report, which was put before government, effectively all of our recommendations, of which there were 69, I always forget, were picked up, and the Surrogacy Act came into effect in 2019. And I'm aware that the Surrogacy Act has been taken up. There are people that currently have current surrogacy agreements under that Act. None of them have yet made it to the court, but you know, gestation takes a while, so we've got to get there. They will get there soon. And that will be a really positive thing that SALRI has been able to do for families. And as I said, it was something that had wide bipartisan support, which is always fun. Because then we went on to our next report, which really threw my Google algorithms out because it went in the other direction. And this is where SALRI had to use everything that had learned in the last 10 years in order to do this consultation well and respectfully, because this is a consultation that had such a wide variety of views and such a large amount of people that wanted to be heard on it. So with surrogacy, we got some community consultation. There were some intending parents that were happy to speak with us. There were a couple of surrogates who were happy to speak to us. And a lot of organisations that do surrogacy work, like fertility clinics and those sort of places. But all in all, we probably had we would have had under 200 submissions made to us.
Also, Anita, we're able to find a happy middle ground that most people could accept.
Absolutely, we absolutely were. With abortion, however, it had a much higher community response. I think Your Say had 2,885, I'm just double checking. So Your Say, for those of you who don't know, is a South Australian website where the government can put up any legislation which they're proposing to make changes to, or anything they want comment on, and people can comment through that link. So they very kindly allowed us to use that, because we just would not have had the capacity, as in the IT infrastructure, to deal with 2,885 emails. Like, it just wouldn't have coped. But in addition to the Your Say, we did get a lot of email consultations. We did a lot of roundtables, and we had well over 3,000 submissions, of which Dave and I had to read every single one of them. And put them all together. So what we had to be very clear on in that is what our terms of reference were. So we took our skills that we had learned over the last 10 years in engaging community and the different ways you can do that, because some people on a reference like this would not be comfortable speaking directly. They would prefer to email, they'd prefer to have some anonymity. Some people really wanted to do that face to face, so we need to factor in all of that. But we also needed to know how to ask our question and what terminology to use. Now, unlike a lot of SALRI references where we are given the topic, we would like you to look at X and we create our terms of reference, this one was very direct. We weren't given that broad range. You are being asked a specific question, you will answer the specific question. So at no stage was our terms of reference to deal with the biological and religious aspects of when life commenced, and at no stage were we to discuss whether abortion should or shouldn't happen. It happens, it's a medical procedure, it exists. We were to deal with how that happens and whether it should be a criminal offence or it should be a medical, in medical legislation. Now, as I said before, none of us are doctors, none of us had any information about how that process works, so the very first starting point before we could rightfully do our community consultation was to go out to the doctors and have them explain to us, what is it? With the legislation you've got at the moment, how does that practically work? How would you see it working? Once we had that framework of understanding what this actually is, we were able to create consultation questions for the community. Again, owning that narrative of what is your view on this specific thing with these restrictions. And the really good example, you've seen Brooke's video and you saw her questions at the end of that and how they were formulated. Those questions didn't give you the answer that we wanted. Firstly, because we had no idea what the answer was, and we never do with any of our reports. We don't know what the answer is until it is given to us through our consultation. But it's important to phrase it like that. There are other consultations that we've seen, and you read reports when you're doing consultations because you read what other people have done before you. You don't want to start from scratch when someone else has already asked the question. But where you see a report where the question asked gives you the answer, for instance, this thing is a bad thing, tell us why it's a bad thing, those reports cannot have the same weight because people who don't agree with that premise aren't going to submit their views because why would they? They know what the answer is, it's in the question that they're being asked. So you already limit the people that are going to be involved in your consultation. And the benefit of community consultation is getting the community, not a specific set of it. You want everyone to be able to feel like they can be heard and to submit to us. So that's what we try to do. Hopefully we do it well. But the importance is also to not make it Adelaide-centric. We are a South Australian law reform body. We're not an Adelaide law reform body, despite the fact the University of Adelaide very helpfully gives us an office. So it's important to ask people who are outside of Adelaide. And there's two main things that we try to do for that. One is to actually get out there and give them the same amount of time that we give everyone who's in Adelaide. So it means that we jump on a little plane, and that's, I think, the Whyalla Airport during one of our consultations to have that done, but also using all those electronic means so that people can submit through the Your Say or through email, or particularly during COVID, we did a massive report where consultation was predominantly done during the COVID lockdowns. So Zoom was just the best invention, and doing Zoom with David's IT skills is an experience that everybody should have at least once in their life. But it isn't, as David said earlier, it's not law reform for lawyers, it's law reform for the community. And what we see in reports that have elements that are outside of the legal, things that are social, things that have policy elements, that's where we need to start using our colleagues in the medical faculty. It's where we need to start using doctors and experts. But most importantly, where it's something that is social policy, it's where we need to use the community. Because if we don't, then our answer is based on only our knowledge, and that's not good enough for a report that's going to be given weight and used to potentially make new legislation. So as I've sort of touched on already, it's not enough these days to just consult with a specific set, and it's not enough to consult in just a specific way. So back in the days of the Law Reform Commission, if they consulted at all, they did it by writing to law societies, lawyers, specific experts in the area with a very set, here's what we're doing, here's what we want you to comment on, please tell us the answer. When law reform evolved, and this is Australia-wide, it's not just in South Australia, they started doing it in a very legalistic way because law reform institutes were made up of lawyers. So they did massive white paper documents, things that will absolutely put you to sleep without your medications. And for someone who is a lawyer reading it, it's boring. For someone who's not a lawyer reading it, it's indecipherable. How can you possibly get good consultation from something that someone can't be bothered to read because it's this big and they're actually only interested in 2 parts of it? That's why we created the consultation videos. Initially, they were very bad. Then I got hold of them and they were partially bad. And then Brooke and her class got hold of them and they are 1,000 times better. But we still look to improve and hopefully we will get better again. We started using things like Your Say so that people can answer very specific questions in very short answers so that they can just give their views quickly and efficiently. We have the email options and letter options available to people that aren't comfortable with email if they want to do something bigger or they want to give us something to actually consider which is larger. And then particularly for organisations, we have the round tables which are all done so that people can sit down and have an opinion. And for those who have formulated their views but are not necessarily 100% set on them, those round tables can be very helpful because they're also directly hearing the views of other organisations in their areas. So for instance, we might do a round table which is all disability advocacy groups. And so they can hear each other speak about things that they might not have thought of, and then they can go away and prepare submissions that they can then send through to us that cover things that not only that they had thought were important, but they've now heard and also think that they want to make comment on. So hopefully, I think that's it for me for the moment on those issues.
So we've talked about how important consultation is and going out to the communities, and obviously Anita mentioned flying over to Whyalla for one of her references. On our most recent reference, we went down to Port Pirie and Port Augusta, and the reason that we do this is so that we are actually in the community and able to show those regional and rural areas that we are genuinely wanting to see what they need, and also to make sure that what we are suggesting for reform will work throughout South Australia and not just in Adelaide. Country areas, rural, regional, have additional challenges when it comes to accessing certain things. So our most recent reference was communication partners, and our communication partner is someone who goes and assists someone who has a complex communication need, whether that be a language barrier or an intellectual disability or autism or a cultural difference. Go with them so that they're able to tell their stories, so that they're able to say what happened to them, or if it's outside of a criminal context, what they're wanting or what they think they want to put forward in a legal argument. So we go out to the regions so that we can find out what we would need to change that's different so that we can get the model to work the same way or a similar way or to the same amount of effectiveness in the country as we do in the city. And while we're on these trips, we are able to go and speak to Aboriginal elders and have that genuine, honest consultation that David spoke about before. And it's really amazing going down there. You know that what you are getting from these Aboriginal elders when you speak to them is something that could actually potentially lead to change and lead to effective reform for Aboriginal communities. And a very big part of that as well is not just going down once, but to go back again. So we did 2 trips to Port Pirie and Port Augusta this year. The first was a law reform trip. The second one was a new initiative where we took a group of 8 students down to show them what it would be like if they were to go into regional practice. And while we were there, we were able to go back and meet with the groups that we'd spoken to the first time to go, this is what we've heard from other people between the period that we saw you in March and June. This is what we're thinking. What are your thoughts on this? And we're able to show them that we do actually care, that we are actually going there to hear what they think will work and actually put that into effect rather than that sort of ticker box consultation that Anita mentioned earlier.
And the Aboriginal community's made it very clear to us. So we've, and all credit to John and David, who run the Law Reform Institute, because they have made it a real focus to make sure that Aboriginal people are heard in our consultations and have the opportunity to speak to us. So every consultation, whether it relates directly to a specific issue that arises with an Aboriginal community or not, they're always invited to attend, and we always follow up. And where it is an issue that relates to them and there's a chapter in relation to them, we always take a copy of the report down so that they can see that they're being heard. And that really, I think, came to fruition in this last report, where they came to us because this is an issue that is massive for their community. Not only for the members of their community because of the communication needs and cultural misunderstandings, but also because of the real difference between access for regional and rural, where their communities are based, and Adelaide. The current model had paid professionals professionals who were volunteering, and then went to a paid professional model. But all of those people tended to be based in Adelaide. That doesn't really work when you're 3 hours away and are about to be interviewed by police and need that assistance. Particularly with technology difficulties. While we would love the internet to be perfect everywhere, it's not, and we'd heard that in previous consultations. So things like doing Zoom assistance just doesn't work, particularly where there's a communication need. We know it exists, but we don't know what it is yet. So that really requires in-person support. So they came out in force to liaise with us in relation to this report. And what we were able to take from that not only was some really great suggestions for their communities, but for the regions as a whole, because they were really an example of what happens when you are really outside of Adelaide and the resources are just diminishing as you get further and further away.
So this kind of goes back to what Kirby was saying, and the fact that it's not just for, law reform's not just for lawyers. Now, if you want to actually suggest reform that's going to work for the community, you need to go out, you need to engage the community, and as we were saying, different groups in the community. So Aboriginal groups, you need people in the regions. In our current reference, the reference we just did, we went and spoke to a lot of health practitioners, because they would be the ones who would potentially be acting as communication partners if they were needed. So it just goes to show how important it is to make sure that every person in the community is able to be heard on a matter if they want to be, which goes back to what Anita was saying before.
And it is one of the most time-consuming and expensive parts of what the Law Reform Institute does. It would be much quicker and much cheaper for us to sit in our office, read a bunch of articles that have been written and some medical reports and type up a report. That would be quick and efficient and cheap. It would also be of little to no use, because it would be reciting what someone else has already done, and it wouldn't have that practical impact for South Australia. South Australia is not the same as Victoria, New South Wales, Queensland, Western Australia. It's not the same as England and America. It is South Australia, and what it needs is different to everywhere else. Some things might overlap, absolutely, and national consistency would be great for a lot of things. But South Australia has huge regional areas which some states don't have to deal with. We need to factor that in. So the only way to do that is in consultation. But there has to be a line, because consultation for consultation's sake is a waste of time and money. Not just our time, but the person who's taking the time to speak to us. If they're not going to be heard, it's a waste of their time and it's just disrespectful. So if it's not something that they have any interest in, we shouldn't be trying to drag them along to it. If we're not going to listen to them, we certainly shouldn't be asking them the question. So one of the things and one of the reasons that I think SALRI has been able to engage with the Aboriginal community is because we do listen and we do include them in our reports, and they understand we're not an advocacy body, so we can't get them the result. But our reports have been used to such success that a lot of the legislation has factored that in, so they've got the benefit that way. But in a lot of other areas, they do feel that people come, listen to them, leave, and nothing ever happens. And they do have that consultation fatigue. It's something that the Australian Law Reform Commission is struggling with quite heavily at the moment in a number of areas. So we are very mindful of that. We're mindful of the time it takes. We're mindful of making sure that we don't try and do full day consultations with people, because that's just tiring. It's a lot of mental stress for them, especially if it's something that is a sensitive topic, which things like abortion and surrogacy, people go, oh, that'll be sensitive. But things like communication partners, we're extremely sensitive because some of the stories that we were hearing about people's experiences really hit to the heart of their engagement with the legal system and for Aboriginal people with white society. And you couldn't put someone through that for a day. So we're very alive to that and we try to be very careful around that issue.
Probably skim over this.
So I have spoken a bit about the communication partner reference already. So we did have a model in South Australia prior to our reference, but unfortunately it wasn't used really at all. So we ended up having the funding pulled from that, which meant that it then became inaccessible to a lot of people because it meant that it became a user's pay scheme. And a lot of people who have a communication need don't have the resources to pay to have someone there, whether it be throughout an entire criminal law proceeding or through a family court proceeding or even just a civil proceeding. So we went out, and as Anita was saying, starting from people who actually know what they're talking about. We started with the people who were a part of the initial program and who had trained people to be communication partners. And from there, we were able to kind of look at, well, what did work well? What can we do this time to get more people knowing about it so that we can get an effective scheme that is going to help people tell their stories in the court. And this was something that initially people thought, and in other jurisdictions, has really only been used in the criminal law realm. But through our consultation, we saw that it has application in all areas of law, especially matters involving Department of Child Protection and family law, where you have vulnerable people, including children, who aren't going to understand the court process and may not necessarily be able to tell the judge or their lawyer what it is that they're wanting or what it is that's happened to them. So this is basically what I just said, so I'll skip over this for you. So as I was saying, themes for our consultation, our research, we were looking at why the previous model maybe didn't have as much uptake, what we could do this time to increase that uptake, and who the best person would be to be a communication partner. And what we found was that you can't really just say one group of professionals can be a communication partner. It really depends on the situation. So some people, the best person to be a communication partner might be a speech pathologist. If it's someone from an Aboriginal community, it might be best to have someone from that community to help them if it's a cultural barrier or a language barrier. It also doesn't necessarily have to be a person. There is a court dog called Zero who can sit with people giving evidence, and for some people that might be all they need, or some people have devices where if they've got that on them, they're able to touch a screen and that can speak for them, and that is all they need to communicate. So it's one of those things where you can't just have one model for everyone. It needs to have flexibility so that people are getting the communication partner that will assist them the best. And also, as we were talking about before, the difference between city and the regions, you need to have something that can apply to both, and you can't have one scheme because the areas are just too different, the accessibility is too different, and if you try and push a city model into those rural and regional communities, they're just going to not have the same access to justice as people in the metropolitan areas are.
So, in conclusion, what's the key points that SALRI has learnt over the past decade? Well, there are different law reform models. The emphasis needs to be independence, impartial. As you've heard from both Brooke and Anita, there is a need for high quality, multidisciplinary research, reasoning and writing. One of the things to consultation, making it accessible to the community doesn't mean dumbing it down. One of the themes we heard from, say, Aboriginal communities and the disability sector is they really resent patronising consultation. So the need for it to be appropriate and respectful. One of the other things we've picked up is the need for a project to be topical. There's, in my view, similar to Justice Kirby, even black letter law, the most technical aspect of trust law, raises issues of public policy. So it needs to be something that's topical, makes a difference. I repeat though again, obviously we look at some very complex sensitive issues, abortion, surrogacy, LGBTIQ discrimination, the offence of homosexual advanced offence. We can't be an advocacy body. There's a fine line, but it's a really, really crucial line for our role. What I'd like, I think, one of the unexpected strengths that's emerged, I think, is the student input. Brooke?
Yes, I think we've talked a lot about the student input, but it's just something that's so unique to SALRI, and just the reference that we just did wasn't something that I looked at when I was in class, but our other student researcher, Simone, did, and just seeing how much work she'd already done and how that was such a great foundation when we then went to go and do our consultations, whether it be through the video or going out to the regions or just at our roundtables with our professionals. Without having that foundation there, it just would have meant so much more work for us once we kind of hit the ground rolling. And as we said, we're not a big institution. We don't have a lot of funding. So without that input from the students, we just wouldn't be able to create the same type of work that we produce, and it just wouldn't have the same impact.
And I think the other thing about the student input is it really the enthusiasm, the commitment really shows through. I want a recent reference. Holly Nichols, who's the other RA in Brooke, they did a number of the meetings with elders, members of Aboriginal communities, members of the disability sector. And it was really disappointing. In 2021, one of the elders turned to, I think it was Brooke and I, and actually said, "Thank you for listening to us." Anita mentioned, or Brooke mentioned, the second trip that we did. One of the members of one of the Aboriginal NGOs said, "You actually came back," meaning that we'd actually gone back to follow through. Sadly, some of these communities, particularly Indigenous communities, are used to this fly-in, fly-out model. One of the service providers called it the white Toyota mob. Sadly, a lot of consultation is done that way. And I think this really illustrates the point, the themes of history. With all respect to the great work done by the South Australian Law Reform Committee, SALRI, though not identical to the ALRC, draws on the valuable themes from Justice Kirby's inspiring legacy as chairman of the ALRC. Law reform is not just for lawyers, particularly in 2021. For those of you who are interested, there are various other projects. Powers of attorney and elder abuse was a major project we did. We haven't got time tonight. That's our website. Feel free to have a look there and you'll see our reports. Thank you for kindly attending tonight, both of you, those in person, those online, and a warm thanks to Anita and Brooke as ever for their erudite and enthusiastic contribution.
Thank you, David, Anita and Brooke, and congratulations to SALRI. That is a really great overview of what has been a very successful 10 years by the sounds of things, so congratulations to you all.
Thank you.
Okay, I'd like to now briefly kick off the Q&A. We're running a little bit tight on time tonight, but for those of you who are listening online, please submit your questions to the Q&A panel down below, and we also can have questions for those of you who are here in our live audience tonight. Just to start off with, David, we received a number of questions regarding legal advice in our pre-submitted questions, and that, from the talk tonight, it sounds like it's not the role of SALRI. So could you perhaps give some advice on where people could go if they're after that kind of advice?
I can answer this in 20 seconds. Members of the public or the community who have legal problems, we cannot give individual legal advice for professional and ethical reasons. There are many great private law firms. There is the Law Society, the Citizens Advice Bureau, the Legal Services Commission, and community legal centres.
Beautiful, thank you. While we're waiting to see whether there's any questions from the audience here tonight, we have another pre-submitted question. So the question is from John, and he asks, has SALRI any proposals or initiatives in restorative justice?
Restorative justice is an interesting area. However, we can't just look at, as Anita touched on, an area because it's interesting. It could lead you to like a wide kind of unstructured exercise. So I wouldn't entirely rule it out. But going back to the point I said before, I should have said practical, topical, and specific. So there are pros and cons with restorative justice. It's certainly not a current reference. As Brooke said, we have a number of issues that we kind of keep on a watching brief, relating to technology and the law, some issues of sentencing, restorative justice. Some issues are better left for academic think tanks. That might be such a body, such a reference.
Okay, thank you very much. And just, I guess, a general question to you all. You mentioned a lot tonight about community engagement. It sounds like that's very, very important. Do you also receive suggestions from the community in different projects that you might take up going forward? And if so, how can the community engage with SALRI?
I think this came up in the previous reference. Yeah, seriously, if you think there is a topical, specific area of law reform, please write to us. We are open to receiving suggestions. Unlike other law reform bodies within government, we don't simply rely on the government of the day for our references. So you can get in touch with either myself or with Anita, or simply just write in to our generic number. However, I do have to emphasise, clearly we do have limited resources. A reference to do it properly, as Anita said, consultation is time consuming, so we have to be selective in the references that we do. The communication partner reference that Brooke and Anita spoke powerfully about, that was one that was actually initiated by SALRI itself because of issues raised by the disability sector.
So for any member of the community that does want to write in with a suggestion, if you also have a suggestion with who would like to fund it, that is also well received, because then we can obviously approach them and say, look, this is an area that would be of benefit to you. Is this something you would like to put some dollars behind as well? But for something that we get where we think it is going to make a real difference, we have some very limited places we can go for resources, and if they're happy to fund it, then it can become a project. But if they're not, unfortunately, it doesn't get off the ground.
It's always the difficult part, isn't it? Okay, I'd like to finish off tonight by once again thanking our speakers tonight, David, Brooke and Anita, for the fantastic presentation. It really was a really great overview of what SALRI has achieved over the last 10 years, so thank you all once again. I'd also like to thank you, the audience here tonight, and also the audience watching online for attending and for your comments and questions. Now, this is our final lecture for the year, so we look forward to inviting you back again next year for our 2022 Research Tuesday program. This has been another tough year on events, but we thank you all for supporting Research Tuesday lecture series throughout our ups and downs and our both online and live events. Be sure to sign up for our mailing list to receive the latest information about Research Tuesday related news, and keep a lookout for our end of year survey when you get the chance to recommend what topics you would like for next year. So thank you once again for tuning in, and we hope to see you next time. Good night.